the mother of the boy who was driving has got regular bail from this court.
The father is
in jail. I appear for a person, my lord, whose child was not there. I am supposed to be a friend.
And I am
the allegation is that the friend went there to help, my lord, that boy, and my lord was entangled in this. That's the allegation.
And
see, what is the ultimately? Parents are unable to control children. They take the key of the car and.
Your lordship are right. And that's right, 18. That's right. I think your lordship is also striking a balance.
Actually, the driver was.
Parents.
Actually, the drivers were driving. It was not the child. The driver was driving. And the child was sitting there. He told the driver, "You should drive." That's the nature of allegations, Lord. These are the kind of things which happen at
My lords, today it's for bail, my lord. Lordship may grant us bail, my lords. And please, yes, please say.
No, my lord, what I am concerned and what I wanted to show that the trial is being derailed, my lord. The trial is being derailed. Let's see page 81. That's what I was showing. They refuse to argue the discharge. They say we will not argue it. Repeated adjournments, my lord, by this Ashish Mittal. That's page 81. This is peculiar of my counter. This is the Roznama of 15/9/25 minute. Please just see the bottom.
Yes.
Considering the last 4 lines, considering the above facts and the fact that the application exhibit 2110 of accused number 9, which is Ashish Mittal, for adjournment is rejected, there appears substance in the contention of the prosecution that the present application is taken out with the intent to protract the matter. As such, the application is devoid of merit. On inquiry, advocate for accused number 9 submitted that he is not going to advance argument today on discharge application. And as to framing of charge, as advocate for accused number 9 failed, then will at the next page. That's a July. That's a
suit out because they are in jail.
Will they take a stay from the High Court? Page 90.
The council made a statement.
Page 90.
They are in jail for 1 year.
In jail, how will it suit?
And your part, 1 year, 4 months.
1 year, 6 months from me.
From August of 2024.
More than 18 months.
1.
4, he was arrested.
All are about 18 months.
About 18.
Page 90. Page 90.
18 months.
Will at page 90 for a moment.
2024.
May of 24.
19th May 24, my lord, is the date of incident.
Therefore, my lord, the delay is at their instance is what my effort is. See page 90.
Can I just show you one
Conditions quote. If that
Yes.
can always.
one para of
Please do that.
one para of the impugned
Because there is a
judgment?
stay by the High Court. There is now a stay at Ashish Mittal's instance by the High Court of framing of charge.
The High Court has granted the stay.
Very well, Millard.
The High Court has
No,
granted.
no,
You
Millard.
can't take
Therefore,
the High Court for that.
So therefore, I am saying, Millard,
They have a whole.
therefore, Millard, no, the submission is, I am not saying, Millard, the submission today is that the plea that trial is taking a long time is not attributable to the prosecution.
It's taking a long time.
Very well. Can I just show you a para of the impugned judgment, if I may, because that's also a High Court. Para 24 at page 26.
Yes.
If your lordships have para 24. From the facts and circumstance of the case and the material on record, it is evident that applicants Vishal Agarwal and Arun Kumar Singh are financially well placed. Witnesses like the private drivers, watchmen, and domestic aid were working with them for a considerable time prior to the accident. Arun Kumar Singh and Ashish Mittal are very close to each other. The hospital staff who are witnesses and were associated with Dr. Halnor to take blood samples, etc., are his subordinates. The student from whom the bribe money was recovered is junior to Halnor. All these witnesses, including Halnor, have been working under Dr. Taware. The statement of the car driver of applicant Vishal indicates that the grandfather of the CCL tried the money power to make him accept that he was driving the car at the relevant time. In the wake of above, if bail is granted to the applicants, even subjecting them to stringent conditions, there is every possibility of their tampering with the prosecution evidence using their money power and superiority dominance. This would ultimately thwart the course of justice in this case, which was exposed to danger soon after the accident, because, as highlighted by the learned special PP, there was unusual delay in the medical examination of the CCL and his two friends. Secondly, the belatedly recorded statement of Adi Sheikh also hints at that danger. Now, para 29, my lords, for a minute.
But there's a presumption that they will tamper.
I beg your pardon?
There's a presumption.
No, Millard, there is a DNA report that they were tampered.
There is a DNA. There's a report. There's a report that is tampered. So, yes.
Blood samples were tampered.
Yes, Millard.
2 passengers.
Just one page.
We're not accused.
Drivers was tampered and 2 passengers were tampered. All 3 were tampered.
Yes, see, all 3 were tampered.
They are the parents of the 2.
Millard, this
Who all conspired to save the main juvenile driver.
I don't know. These minors
Millard,
go to jail.
the submission is That only because their children were sitting at the back can't
Not
be a
my
fact
child also.
yours to their benefit.
Not
But
my child.
ultimately the attempt was to cover up the whole thing.
Absolutely.
The trial
Yes,
against
Just the direction here,
Without one more
the
thing.
direction at para 29 is
Came from the High Court.
that the bail request can be renewed after material witnesses are examined. That's what the High Court has said. Material witnesses are about 15 material witnesses. No, if your lordship is going to direct for it to be expedited, then it can
Charge is
be.
not framed.
Case with the UAPA case was.
My learned friend is not a complainant. How can he be in charge of the trial?
And charge is not framed, I might be discharged.
If it's only a case of rash and negligent driving, nobody would be opposing it. If you undermine the justice system with corruption, bribery, and money power,
Before that,
which we can hear over here,
I might
in a large volume, there's a problem. There's a
Is
problem.
this the case, this is the only case to be expedited, only this?
common order.
Grateful.
Learned, we have heard learned senior counsel for the appellants and learned standing counsel for the first respondent state, and you are
I'm for the parent of the mother. I had been, of the girl. I had been allowed to intervene. Yes.
senior counsel for the pleading applicant, who have all vehemently argued their respective cases.
She's not relevant.
Learned senior counsel for the appellant submitted that insofar as the appellants in, you write, in item 69 and 69.1, write those, are concerned. They are the concern. They are the no allegation or offense has been alleged against their wards. In fact, the appellant in item 69 is a friend of the father of the child who was in the back seat of the car. And the appellant in 69.1, right there, or whatever, is the father of the child who was in the back seat of the car, which is said to have caused, the driver of which is said to have caused the accident owing to rash and negligent driving, resulting in the death of two innocent persons on so and so date. The appellant in 69.2 is stated to be a driver of the
No, Lord,
whose driver?
he is just a middleman who allegedly received the amount from the driver of the parents of the juvenile and handed over to assistant of the doctor.
It's not a driver.
No, he's not the driver. Driver is not even made an accused in the
Stated
case.
to be within inverted commas, middleman who had received a sum of rupees 3 lakhs for the purpose of replacing the sample of blood of the wards, of their wards,
One of the walls.
of the two juveniles who were in the back seat.
He did not replace, he just handed over to the assistant.
That's the allegation.
That is the allegation.
That's the allegation.
Stated to have handed over a sum of rupees 3 lakhs to the
Assistant of Dr. Halno.
to the assistant of doctor,
Hello.
say in paragraph 20, so and so. It was submitted that since there has been no allegation whatsoever as against the two juveniles who are in the back seat of the car, it is unlikely that there would have been any kind of attempt made by these appellants for replacing the blood sample of the said two juveniles who are in the back seat of the car. However, since the allegations have been made as against these appellants, they were arrested and are in jail for a period of
More
1 year,
more than 20 months.
for
More than
nearly 18 months. For nearly 18 months. It was submitted that even as against the driver who had caused the accident, the punishment is only up to
3 years.
3 years.
3 years. Even if it is held that it was the juvenile who had caused the accident, the said perpetrator is now being proceeded against before the Juvenile Justice Board. In the circumstances, it was contended that continued incarceration of these appellants in the absence of there being any progress in the trial and possibility of there being a delay in the conclusion of the trial, since there are as many as how many witnesses?
More than 100 prosecution witnesses are cited.
Nearly 100 prosecution witnesses would cause great prejudice to these appellants. In the circumstances, it was contended that the impugned orders may be, there are three separate or common orders.
Common order.
Impugned order may be set aside and the relief of bail may be granted to the appellants herein, subject to the terms and conditions to be imposed by the court. Per contra, learned counsel, for the respondent state, you have filed your counsel with reference to his counter affidavit contended that any release of these appellants would inevitably frustrate the trial itself, inasmuch as the allegations as against these appellants are not just on under section 201, but also under section
467 minutes.
468,
No, 466.
467 and other provisions of the read with section 34 of the IPC.
We've given these two lists.
Yes. And hence, as well as the motor vehicle won't come to them, as well as the provisions under the Prevention of Corruption Act. And hence, the no leniency may be shown by this court with regard to these appellants. Learned senior counsel appearing for the impleaded respondents also supported the learned counsel for the state and contended that the conspiracy between these appellants and the perpetrator and the father and the parents of the perpetrator, the alleged juvenile driver who caused the accident, is clearly evident. And if at this stage they are permitted to be released, then the trial itself would be jeopardized. He therefore submitted that there is no merit in this and the same may be dismissed. All right, allow. Let them be produced before the concerned trial court as early as possible. They shall be released on bail subject to such conditions as it may deem appropriate to impose, so as to ensure their presence in the proceedings arising out of FIR so and so. The appellant shall extend complete cooperation in the trial. The appellant shall not misuse their liberty in any manner. Any infraction of the conditions shall entail in cancellation of bail granted to the appellants. Once again.
Just one. Contact the witnesses, directly or indirectly, because that's bound to happen. It's already happened.
In which case, will at liberty to the state to move for cancellation.
That's a condition.
Excuse the liberty shall cooperate. All right. The appellants shall not make any attempt to contact the witnesses either directly or indirectly. We have said any infraction, you have the right.
Yes.
Would your lordships consider one more submission? The father of the juvenile who was driving and the other, the hospital staff are still in jail. They are not before your lordships. Would your lordship consider observing that this may not be a ground of...
It would be very peculiar.
Because for them, I'll differentiate. This is very peculiar because two things, Bharat.
Yes,
Why should you care?
we have to close that.
There's no
This is very
conspiracy, Mr.
peculiar.
Agarwal. Why should you care?
This is very peculiar.
No, I don't understand why it should concern you.
This case is not before us.
Yes.
Very well.
There's no conspiracy, but he wants to defend them. I'm surprised.
You want to pass a prejudicial order against this?
No, Milord, I was not saying.
See, this is not says anything.
But because against them, there is also prevention of corruption.
Correct.
Lord, I'm sure my learned friend will oppose it when and if she comes, and if I'm on this side, then it will be the same thing. We'll repeat it, my
The
Lord.
father and the mother we blame
Yes,
for not having
absolutely.
control over
Lordship
the
is
children.
in. Lordship is.
To blame them, they don't have control over their children.
That's right. Lordship is.
Now over if we say anything in that line, We are only afraid it should not prejudice the trial of the case.
That's the purpose.
I have more to say on all this.
Yes.
No, a celebration is not on the basis of substance.
That's right.
And then going in a speed, top speed and resulting in killing of innocent people on the road or innocent people sleeping on the road, on the footpath. This is not the first accident we have noticed.
That's right.
My lords, I'd
There
be
are-
pleased to observe.
And it all follows the same pattern.
Yes.
Get some poor driver to take the rap saying we were not driving, that person was driving. Replace blood samples, say no alcohol, 3 years, paste the rap and go.
My lords,
Here the law has to catch up on these people.
Yes. Full rigor.
Most obliged.
No, most importantly, the parents are responsible for handing over the vehicle to the children and giving them sufficient funds to have a gala time. This is the problem because parents have no time to talk to the children, have a dialogue with them, spend time with the children. So what is a substitute? Money, ATM card.
That's
So they go on their own way and a mobile phone. We have much to say on this.
absolute.
See, 2 innocent lives are lost and then all these machinations happen. But only thing in your favor is that yes, there's a long incarceration.
that's it.
So liberty versus all this
Lordship.
ultimately.
Great.
Please advise your
We'll
partner.
do
We'll do that. We'll do that.
Believe me, my lords, they have learned a lesson of their lives, my lords.